17, 18.
We're live.
Good evening. This is a voting session of the House Judiciary Committee. It's a little after 6:30 on the 26th of February, 2021. Gonna do my best to, we've had a long week, try and get through a fair amount fairly quickly. We're going to start with a range of withdrawn bills. There are 1, 2, 3, 4, 5, 6, 7, 8, 9. I'll read them out. The House Bill 198, Delegate Wilson, disturbing the peace. House Bill 241, Delegate Wilson, regarding search warrants. House Bill 362, Delegate Valentino Smith, on probation and juvenile law. Delegate Crutchfield has 4 bills that she's withdrawn. House Bill 502, regarding prosecutorial information. 698, regarding a model prison study work group. 1028, regarding placement guidance for dispositions in juvenile cases. 1029 for juvenile court jurisdiction. 1093 is Delegate Polakovich Carr, and it has to do with real property. 1116, Delegate Wilson, juvenile law and custodial interrogations. I'd like to move to put all of these on a consent calendar and move them all unfavorable.
Second.
Moved and second. All right, we're going to just do this. We'll do this audibly. All in favor of the unfavorable on all of the bills, say aye.
Aye.
Any opposed to the unfavorable? Motion carries on the unfavorable withdrawn. All right, that was easy. Let's see if we can screw this up now. I mean, how we can keep going. House Bill 271. House Bill 271 is Delegate Ebersol's bill. We passed this last year. There is an amendment that conforms it to the way it was passed last year. If I'm wrong, Claire will tell me. I don't think I'm wrong. However,
There's a few changes, just very minor, requested by the advocates, just mainly terminology, but otherwise it's the same as last year.
okay. Are there any I'm going to move the amendments. Is there a second on the amendments?
Second.
There's a second on the amendments. Discussion on the amendment? Any discussion? All right, all in favor of the amendment?
Question.
I'm sorry, Delegate Conaway?
Do we have the vote count from last year?
I think it was one that everybody voted for, but we can.
Okay, all right.
Yeah, it was
good.
unanimous.
It was unanimous last year.
Thank you. I thought so. Thank you.
All right. So we're on the amendment. All in favor of the amendment, say aye.
Aye.
Anybody opposed to the amendment? Nobody in opposition. The amendment's adopted. Could I have a motion on the bill as amended?
Move as amended.
Motion and a second. All right. Any further discussion on the bill? Delegate McComas, this is House Bill 271. We're passing it in the same posture as we passed it in 2020. And it was a unanimous vote that time. All right.
Mr. Chair, Delegate Cox is trying to log in right now. I just spoke with him.
Okay. Dylan, can we see Delegate Cox? Not in the waiting room.
I think he's in his car, so it might be taking him longer.
Oh, boy. All right.
Oh, well, let's keep going.
We have a motion. We'll keep an eye out for Cox, and I'll let him come around here in a second. All right. We'll do a roll call on House Bill 271. 271, giving Cox just another second here. All right. The roll call, the Vice Chair.
Yes.
Delegate Anderson.
Aye.
Erican.
Aye.
Bartlett.
Yes.
Hardin.
Yes.
Conaway.
Yes.
Crutchfield.
Yes.
Deborah Davis.
Yes.
Juanica Fisher.
Yes.
Grammer.
Yes.
Griffith.
Yes.
Lopez.
Yes.
Malone.
Yes.
McComas.
Yes.
Oh, boy. Moon.
Yes.
Shetty.
Yes.
Cham.
Yes.
Watson. Ron Watson.
Yes, yes, yes.
Yes. Williams.
Yes.
Delegate Cox. He's on. Delegate
Mr. Chair.
Hi, this is House Bill 271. It's Delegate Eversol's bill. We passed it last year unanimously, and we passed an amendment to conform it to what we passed last year.
I apologize for my login trouble. I'm a yes.
Okay, thank you very much.
Thank you, Mr.
So that bill passes with 20. Delegate Jones, Delegate Rachel Jones is excused on all of these votes because she's going to a family wedding. House Bill 366. 366. I do not see any amendments to 366.
Move favorable.
There's a motion
Second.
for favorable in a second. Is there any discussion on 366?
Yeah, what does it do?
Right, Delegate Cardin, would you like to tell the group what it does?
This allows a district court judge or a circuit court judge, I think, but a district court judge to change a warrant, a warrant to a summons. It really just affects Montgomery County. Every other county already does it.
Delegate Anderson, do you have any further questions?
Yeah, I mean, what's the difference? Why is Montgomery County so different?
I think it's a
The
local
way
custom, if I remember.
apparently the way that they read the law, they don't their judicial conference of Montgomery County doesn't think that they have the authority to do it. They would like the authority to be able to do it. That was, I think, the testimony.
To recall an arrest warrant issued by a court commissioner. They don't think they have
Correct.
to do that. All right, fine.
In my experience, judges in Anne Arundel, I know in Baltimore City and a bunch of other places believe they have the ability to do it, but you know what? We're going to make it clear. They have the ability to do it.
All right.
All right. Are there further questions? Seeing none, there's a motion and a second. We'll do a roll call. The vice chair,
Yes.
Anderson,
Aye.
Erican,
Aye.
Bartlett,
Thank you.
Bartlett,
Sorry, I just froze all of a sudden. I'm here and that's a yes.
okay, Cardin,
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanika Fisher,
Yes.
Grammer,
Yes.
Griffith,
Yes.
Lopez,
Yes.
Malone,
Yes.
McComas,
Yes.
Moon,
Yes.
Shetty,
Yes.
Cham,
Yes.
Watson,
Yes.
Williams.
Yes.
All right, that's 20. All right, we're going now to House Bill 425. This is Delegate Barron's bill on ransomware.
Move favorable. Second.
We have an
Well,
amendment.
there is an amendment. Delegate Grammer has an amendment and Delegate Grammer, if you want to press the amendment, would you like to describe what the amendment does?
Yeah, so this amendment fixes what I think is both a technical and a practical problem with the bill. So in defining what actions a person may take, this bill doesn't actually say anywhere that you can't introduce this ransomware onto a network or a system. What it currently says is you can't knowingly possess with the intent to use it. So for an example, in like a drug distribution, there's a possession charge and a possession with intent to distribute. There is no actual part of this bill that specifies that you can't introduce ransomware onto a network. So what my amendment does is it strikes the word possess and changes it to introduce, that's the word that's used in the definition. and it strikes with the intent to use the ransomware for the purpose of introduction. So it's essentially changing one sentence, and I'll read that to you. I'll read you what it would be if we adopted the amendment. A person may not knowingly introduce ransomware into the computer network, or computer system of another person without the authorization of the other person. So in other words, it's clarifying that the action that we're looking to capture here is the actual, the hack, the deployment of the ransomware onto the system. And the practical issue that it deals with is the one we've talked about. And that's frankly, if people have this software on a closed network in their home for the purposes of just tinkering around with it, the white hat hackers, there's big communities of these people, frankly, that just tinker with this stuff. They never actually deploy it anywhere, but really under the current language, they could get wrapped up in this charge, and the language doesn't actually specify the penalty is for introduction onto the system. So it's really just a technical amendment and specifying that we're looking to get at people who are introducing this ransomware on the PCs, and I would move the amendment.
As I read the bill, the law already as it exists says that you cannot commit an act prohibited under this subsection with the intent to interrupt or impair the functioning of state government or a power system or a service in a public service company, or and then the bill adds a hospital, a school.
Right.
So the law as it stands now says it already addresses the use of ransomware. This, I think the issue for that Delegate Barron talked about was saying, that people do possess it with intent to use it. There's that it's sort of the step right before they seek to do the thing to interrupt or impair any of those things. But there are lots of hands that just got raised. So let's just do this. Delegate Erican.
Thank you, Mr. Chair. I really appreciate this amendment because we did actually work on this bill. I don't know if the CRIM people remember in our subcommittee last year, and we talked about the concerns that we had around whether or not we wanted to penalize people for just possessing this stuff. It's not like child pornography. It's completely different than that. I know that was brought up before because they haven't committed any crime yet. There are lots of young people who do a lot of, self-taught IT related stuff where they do not go to classes and things like that. And they learn how to do these things on their own personal computers. So something that they may have on their computer that is innocuous, could it be used back, for bad things? Certainly it could be if they weaponized it and they acted on that. But just the mere existence of it I don't believe it should be a crime. And that was what I was very uncomfortable with last year when we were talking about this subject, was treating people that just had this software on their computers as criminals when they didn't actually have any intention to actually use it. Could they have used it? Sure. Were they? No. So that was what made me uncomfortable last year. And that's why I like this amendment, because I think what this amendment actually does is it restricts the actual crime to the use versus just the possession.
Okay, I have comments, but I have too many people who want questions, so I'm going to shut up and let everybody talk. Delegate Bartlett, and then we'll go to McComas, Moon, and Conaway. Bartlett.
Thank you, Mr. Chair. So what concerns me with the amendment is that we're taking out the intent element of, and I don't, no pun intended when it says with the intent to use, but it's the knowingly possess. By saying a person may not introduce the ransomware into the computer, that to me seems more like you may get someone who doesn't intend, or that example where a child just does it, and they don't mean to do it, and with all the scams going around. So it seems like knowingly is an important word. So if Delegate Grammer, with your amendment, if you would just keep in the word knowingly, a person may not knowingly introduce into the computer that type of, all of that you had there. It would make more sense to me.
Delegate McComas.
Unmute yourself.
Okay, here we go. Just a quick question. I wanted to know if it's necessary to mention server in the amendment, Delegate Grammer, because server was a big play in the 16 election, presidential election. Remember the server in the.
Yeah, I think the bill is originally drafted. It says computer network, or computer system. I mean, I think that
So a server
that covers.
would be included. Okay. All right. Thank you.
Delegate Moon.
Thank you, Mr. Chair. I have a question about the bill as introduced compared to this amendment, and that's, without having it in front of me, does the way it's phrased as introduced suggest that what's illegal is possession with intent to use it just outright, or did we clarify that the use that's illegal is a malicious use, a introduction without that they intend to use it maliciously or without authorization to place it on a server? Because that might be the missing nexus between what I think Delegate Grammer is trying to do and where the bill is introduced might be. Or maybe this is covered.
Delegate Moon, I'll read you from lines 25 to 28 of the bill on, I think this is page 4. A person may not knowingly possess ransomware with the intent to use the ransomware for the purpose of introduction into the computer network, or computer system of another person without the authorization of the other person. So it is not just mere possession. You must possess and intend to use it.
Intend to use it without authorization from the other party.
Correct.
Okay.
All right, Delegate Conaway.
Thank you, Mr. Chairman and members. I've changed 2 times. One, I think we made it illegal to possess the bump stock. And after people had purchased them, but you can tell me if I'm right about that. But I just remembered that some people have this ransomware on their computer so that if they get hacked, their computer releases the ransomware into the hacker's computer. And then it kind of reverses the ransom, and they have a whole video. If I was thinking I could get you the videos, they have a whole video thing of this where these people let the hackers, the scammers like from India and all these foreign countries, hack their computer. And then when they try to take over their computer and access their bank account, then it unleashes malware. So they have it set up. They have it set up to be used as like an aggressive malware. So that's how they're using it. Instead of just protecting their computer, they take over the person's computer who's trying to take over their computer.
Okay.
So my point is, there's a certain group that are using this type of computer hacking software as a defense for their computers.
But they would have installed it on their own computer, so
they'll
put it onto their computer.
They'll install it on their computer. But let's say if Chairman Clippinger comes in and hacks my computer and tries to access my bank account, once you do that, this malware is released through my computer back through the system onto your computer and locks up your computer, and I take over your computer.
I saw that episode of Star Trek.
Huh?
I saw that same episode.
Okay. Delegate Fisher?
Mr. Chair, I would urge this committee to reject this amendment. I think from the various reasons around intent that was said, and I also would take us back to the hearing in which I forgot which panelist it was now. I don't have my notes in front of me, but spoke about that the mere possession of this is just not a common thing, and it is very dangerous just to even have this kind of ransomware on your computer like that. And I would also, for the current prosecutors and the former, there's called discretion and prosecutorial discretion. And
We heard about that today, I think, a little bit.
right, and so
Number
they
one.
use that to determine when they're going to bring a charge. And so if it's really just on the computer, you've already heard the intent arguments from Delegate Bartlett, and they will either have the evidence to go forward for it or not. So I'd say vote no on this amendment.
Delegate Grammer?
Yeah, I'd actually use that point to suggest why you would support it. They do have discretion, and some of them like to prosecute young girls with child pornography for sexting. And that's the reason why we closed those loopholes. The argument made by the Johns Hopkins professor that I think he used the word ill-advised, that could very well be right from the lips of a anti-drug crusading prosecutor who's looking to throw up everybody who uses marijuana in jail. You know, well, that's ill-advised. Well, it might be ill-advised, but there are entire communities of people who tinker with this stuff. You know, in the 50s, it was, I'm going to play with my truck engine. I'm going to take apart my transmission and put it back together. And for better or for worse, you know, there are entire communities, they have conventions about this stuff, and they invest their own time in it.
Well,
And
can I ask the delegate a question, Mr. Chair?
Delegate Grammer finish, and then Delegate Fisher asks a question.
If you like, what a prosecutor is going to look at for this, he's going to look at it and say, what other purpose is someone going to have this ransomware other than to introduce it onto the other computer? They're not going to say, "Wow, guy's just a white hat hacker who likes to deconstruct software and figure out how it works." He's going to assume that the intent of the possession is to deploy it. And look, this is why I vote to lower or repeal a lot of possession crimes. Possession shouldn't be a crime, and a lot of innocent people get wrapped up, and that's why I have the amendment.
Delegate Fisher, for your question.
Yes, Mr. Chair. My question just, it's a little late, it's been a long week, but was there any testimony at the hearing from these, you say, robust communities saying that they would be charged with possession if they're so robust and, as what you're saying? I don't recall that. So I just wanted to know if maybe I missed something.
I think it's a bit of a false argument. I mean, who reaches out to every community to say, what's your input on this bill? I mean,
A lot of people show up to this committee, delegate,
I get that, but has anybody reached out? Maryland is big on cybersecurity. Did anybody reach out to any of them to say, like, what's your opinion on this bill? You know, the big conventions where they have activists who come and work on these things. Did anybody say, what's your opinion? I just don't think because nobody shows up, nobody disagrees with the bill.
All right, we have three more bits of conversation here, and then we're going to move on. Delegate Anderson first, then McComas, then Conaway.
Thank you, Mr. Chairman. Ladies and gentlemen, I just want to go back to something that the chairman said. I thought he said it pretty clear, is that this is not a bill that makes possession of ransomware a crime. This is a bill that basically says a person may not knowingly possess ransomware with the intent to use it for the
I'm
purpose.
back in my office, wrapping up a voting.
Delegate Malone, you're not muted. Now you are.
So I'm just saying, this is not a bill that criminalizes the possession. It criminalizes the possession with intent to use it in a malicious fashion. And that's a different step or an additional step that any prosecutor has to take in trying to prove his case. You can't just say, oh yeah, it was on the computer, must have been there because he was going to use it. No, he's got to prove that the person was going to use it. It has to have another set of facts in order to prove that. So I'm with the chairman on this one.
Delegate McComas, then Conaway.
Just briefly, and I have not looked at Delegate Barron's bill, but is there a protection for our security folks like at Fort Meade that would be using this stuff for research or for defense to protect us. I know that when we did some other bills, we always provided that, that we made sure that we protected the research and the defense firms working on it, or anybody that was taking security curriculum, because there are computer security courses and things like that. I just want to protect that. Does he have something in his bill regarding that?
I don't believe that I can go back and look at it again, and council again can correct me, but I don't believe there is anything specific here to that specific issue. But again, I think that's because it requires more than simple possession. It requires possession with the intent to use it.
Well, there would be the intent to use it as a research tool or as protection for government agencies and things. That's the only concern, that if it's used, we want to.
They would be using it. They would be using it on their own company's computer. They would presumably have the permission to use it on the computers on which they were doing research, and that's what's allowed in the bill.
Okay, all right, thank you.
Delegate Conaway.
Thank you, Mr. Chairman. I know. Delegate Anderson, so if you tried to access my computer and I have this malware on my computer and I have my computer set up so that I intend to burn up your hard drive and your motherboard because you're unauthorized to be on my computer system, would I be a victim of this bill?
No, because you did not intend to use it for the purpose of introducing to another computer or network system without authorization. You used it to protect yourself.
Okay, thank you.
All right, first, Delegate Grammer, from what he said, I'm presuming is going to press the amendment. That's fine. Delegate Erican, I'm going to take what you said as a second on the amendment. So we're going to vote on the amendment. Since there are people in their cars, we're going to go ahead and I'm going to do a roll call on the amendment because I think that's just the fairest way to do it at this point. All right, the Vice Chair.
No.
Erican.
Yes.
Bartlett.
Hey, you skipped me.
Oh, sorry. Anderson. So sorry. God. Awesome.
You like me more. Sorry.
Sorry about that. Delegate.
So I'm a no on the amendment.
On the amendment, a no. Okay, thank you. Now, Delegate Bartlett.
No.
Delegate Cardin.
No.
Delegate Conaway.
No.
Delegate Cox.
Yes.
Delegate Crutchfield.
No.
Delegate Deborah Davis.
No.
Delegate Wanika Fisher.
No.
Delegate Grammer.
Yes.
Delegate Griffith.
Yes.
Delegate Lopez.
No.
Delegate Malone. Delegate Malone on Grammer's amendment.
Yes.
Delegate McComas.
Yes.
Delegate Moon.
Yeah, why not?
Delegate Shetty.
No.
Delegate Cham.
Yes.
Delegate Watson.
Yes.
Delegate Williams.
No.
The amendment fails 11-9. Now we're on the bill. It is.
Chairman, I presented an amendment, which I do not need to press if we're not going to consider it, but it was an amendment to change the penalty from 10,000 in 3 years to 5,000 in 2 years. I gave it to the I thought I gave it to the subcommittee and to the staff.
We don't have it.
Okay.
We don't have it.
I made sure it was given by 4 o'clock yesterday, so I will yell at my staff because they assured me that.
That's an oral amendment?
We can't do that we really can't do that in our present.
Well, it's a technical difficulty.
No, that's fine. I don't need to press it, Mr. Chair. I had a discussion actually, I think with you and a few other people, and came up with this as a way to maybe make it a better bill, but I'm fine with it the way it is. So
right.
I'm okay.
I
That's
have
fine.
I have the email. He sent it to the entire committee.
Did he send it to Dylan Goldberg? He did.
He did.
All right.
I actually did things right. Look at that.
All right. If it was sent to the entire committee, do you want to press the amendment?
I'm happy to put it out there and take it. I mean, it was just because I know there was some concern. This is a very strong, very high. I mean, this was commensurate with a number of different offenses that maybe it wasn't the same. It didn't have the same level of severity. So I put that in as a suggestion. Bill of the committee is fine. It's not something that I am married to, so I'm not going to press any further than that.
So committee, it would change the penalty from a maximum penalty of 3 years and $10,000 to 2 years and $5,000. He has a motion and a second. Is there discussion on the amendment?
The county is also offering some new ways for homebound residents to make sure they get a vaccine. So county executive.
All right, hearing none.
Whose TV are we hearing?
I'm not sure. Probably Carton. All right,
Delegate Bartlett has a question.
Delegate Bartlett.
Thank you. Before I can vote, I need to I didn't catch everything. I was trying to find the amendment, couldn't find it. Could you tell me just one more time, what is the change? Okay, thank you.
Yeah, let's leave that up just for a second. So this is in line 5, line 16. So if someone violates the possession with the intent to use it, it would lower the penalty from 3 years and $10,000 to 2 years and $5,000. Delegate Fisher.
Thank you, Mr. Chair, and thank you, Delegate Cardin, for this amendment. And you know how much I appreciate you and enjoy your thoughts.
Yeah.
I do enjoy the original penalties in this bill. I think, as we all know, when you go to court with different circumstances, judges are going to have different discretion on jail time amount and fine to really move around. And I think the crime of ransomware, depending what happened, the kind of destruction that maybe, as we saw with Baltimore City and, the hijacking of the entire,
Thank you.
government computer system compared to maybe a smaller thing with an individual, there's a lot of variety in what can happen. And so I think that the max of the 10 and the incarceration as well gives people that space on what can occur. So that's my opinion. So I wouldn't personally be voting for the amendment, but I just wanted to put that out there.
Okay. Any further discussion? Delegate Bartlett, are you coming back around or no? No, you just have your hand still.
Actually, I didn't intend to, but I would like to ask a question.
Go ahead.
I didn't quite understand what Delegate Fisher just said. When you were saying that putting it at 10 gives the judges more discretion. Is that the gist of what you were saying?
Yes, Delegate Bartlett, in the sense of the kind of criminal consequences can vary case to case. You can have someone maybe who hijacked an entire school board system and caused how many thousands of dollars in damage. And you could have someone that maybe hijacked an individual and only caused a fraction of that, right? And so as the prosecutor, you might be like, my recommendation for punishment, Your Honor, is 6 months incarceration, this amount on the fine. And for the person that did the entire, school system, right, it might be a year and a higher fine. I think when you lower that fine, you're lowering that ability to have recommendations from state's attorneys and judges, and for the defense, as a defense person, a defense attorney kind of have movement on, what you're asking for in each case. Sometimes I've also seen in our criminal system when depending on how the fine and punishment is, when you don't have that space, there tends to become a routine in court on okay, on this typical crime, it's just going to always be 3 in this. And when you make it smaller, this is very anecdotal. I don't want to say anything statistically, but judges tend to then find their groove and feel like this is what they give on prior cases with similar facts, they're going to continue to give that crime and punishment in the future. So I do like, this is a very unique kind of crime, and it's a little different than like, I just hit you in the face, or, you know, my first time, whatever, that I think, you know, having it go all the way up to $10,000. And honestly, and I would have to, there's no experts on this call, but these kind of ransomware hijackings are definitely causing way more than $10,000 in damage. Way more to fix anything. So I'm very comfortable, way more. So I'm very comfortable with what is in the original bill.
Okay, thank you. As long as Delegate Fisher doesn't hit me in my face, I'm all good.
How much more?
Delegate Arakan, then Grammer, then Moon, then Cardin. Delegate Arakan.
Thank you, Mr. Chair. I'm just really enjoying this moment where I'm hearing Delegate Fisher push for tough on crime. This is just really fun for me. So my question really is to you, Mr. Chair. Can't the judge order restitution in this case? Like if they make hundreds of thousands of dollars of damage, can't the judge say you have to pay back the victims and also I'm assigning a fine?
In this case, if it were introduced into the ransomware system and that caused damage, that's already a crime.
Right.
Conceivably result in restitution. I think what Delegate Barron's bill addresses is the possession with the intent to use. I'm not sure what restitution would necessarily have to be made unless there was some damage, which then implies that it was actually that next step was taken. So I'm not sure that there's restitution here. The chance that it could create thousands of dollars of damage is real. And we did see it. We've seen it across the state, across the country. So I guess I would associate myself with Delegate Fisher in that way.
Okay. So, and then my other just comment on this is that it's highly unlikely that the people that are doing this live in the state of Maryland for the most part. And so I think if we think about the realistic nature of who we're really looking at is going to be the criminal here, the really big things and the terrible things that are happening are far more likely to be coming from outside. The people we're actually going to be catching with this kind of stuff on their computer, I'm guessing are not going to be anything near as successful in causing the kind of harm that we've been seeing. I don't know of any cases in Maryland where somebody created the ransomware, had it on their computer in Maryland, attacked somebody in Maryland with it. It's almost all from overseas. So
I think a lot of these cases are in fact addressed on the federal level, and that's what Delegate Barron said in his testimony. So this is seeking to provide a backstop, I guess, to them. But again, the fact that the introduction of ransomware happens elsewhere isn't relevant to the crime that he's creating in the bill, because it's the possession with the intent to use it. If he's intending to use it, and you'd have to prove, presuming it's a he, you'd have to show that here in the state of Maryland to go forward. So to that end, if it happens from somewhere else, no, we wouldn't have jurisdiction to go after those people. Delegate Grammer, then Moon, then Cardin.
Thank you, Mr. Chair. So I just wanted to point out, like a lot of these cases, this actually happened in Baltimore County too, and it's a federal prerogative, but a lot of these cases, they never find the culprit. And if they did catch them federally, there'd be federal charges. And I don't know of any state cases. I've never seen an example where states prosecuted this. And, you know, the point of my amendment was my concern over, frankly, the little guy who was not holding a system up for ransom. I fear average people are going to get tripped up in this. And even though the good gentleman did not support my amendment, I would most certainly feel a little bit better if we decrease the penalty a little bit, thinking about the little guy.
All right, Delegate Moon, then Cardin, then we're going to vote.
So I just want to be clear. I think what we're talking about here is how we handle IP address dragnets, because that's really, I think, the main
Delegate
scenario.
Moon, actually what we're talking about here is the amendment, which lowers the penalty from 3 years to 2 years.
No, I guess, but it's related in the sense that we have to determine what's the appropriate penalty for someone caught up in an IP address dragnet. To the chair's point, there's already a crime if an intrusion happens. And so there may be calculable damages, there may be restitution, but there's a whole penalty for that. What's unique about what we're being asked to do here is there may be no damages. There may be no crime, but some intent. Now, this is maybe a question for the chair. Is there also separately the possibility of attempt charges if someone possessed and there's heavy evidence and maybe they took a step or two but didn't actually do it, that provides an additional option outside of existing law anyway?
All right, so I mean, there are a range of what are called the Encode Crimes. I never pronounce it well, but you know, things like conspiracy and attempt. If trying to think that you,
I guess, and I'm trying to just understand where the line is.
you can't attempt to possess something. You either possess it or you don't. So you can't attempt to do the crime that.
But you could be guilty of attempt to introduce malicious software onto a network, right? By mere possession and additional steps.
Well, you would have to actually, again, you would have to actually take those additional steps, which would be more along the lines of actually committing the crime that's already on the books as opposed to not.
Yeah, okay, well.
Yeah. Delegate Cardin.
Thank you, Mr. Chair. Actually, Delegate Moon answered or asked most of the questions. I just wanted to just follow up with that. We had a whole conversation just before about the fact that, well, while no crime, no malicious activity is actually done yet, nothing was done. We're creating a new crime, but nothing bad had happened. This is the possession with the intent to do something bad. Nobody's been harmed yet. So it would seem to me that looking at our possession with intent to crimes or the intent crimes that we have, this seems to be a balanced approach. I'm going to vote for the amendment if you're going to do it if you're going to have us vote by voice, but I'm not going to press that. I just think it's the right thing to do. It's a good compromise and it puts us on the right path.
And so I need some clarification then, Delegate Cardin. Are you pressing the amendment?
Yes, I am pressing the amendment.
All right, then that's what I needed to know. There was a second on the amendment. And we're going to go ahead and we're going to take a roll call. The Vice Chair.
No.
Anderson.
Unmute.
Yeah, I'm trying to unmute. I'm voting yes.
Erican.
Yes.
Bartlett.
No.
Cardin.
Yes.
Conaway.
Yes.
Cox.
Yes.
Crutchfield.
No.
Deborah Davis.
Yes.
Juanika Fisher.
No.
Grammer.
Yes.
Griffith.
Yes.
Lopez.
No.
Malone.
Yes.
McComas.
Yes.
Moon.
Yes, to create the most unusual voting coalition we've seen yet.
Shetty.
Yes, to join that coalition.
Cham. Cham.
Yes.
Okay. Watson.
Yes.
Williams.
No.
All right, 14-6, the amendment's adopted. We're now on the bill as amended. All right. Further
Move favorable.
discussion? I think we've beaten this one pretty good. Knock this one. All right.
Move favorable as amended.
There's a motion
Mr.
for
Chair.
favorable and it's amended. Is there a second?
Second.
All right. Roll call, unless there's further discussion. Roll call, the Vice Chair,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Cardin,
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanika Fisher,
Yes.
Grammer,
Yes.
Griffith,
Yes.
Lopez,
Yes.
Malone,
Yes.
McComas,
Yes.
Moon. Moon? You lose him?
I think he got kicked off, yeah.
Shetty,
Yes.
Cham,
Yes.
Watson,
Yes.
Williams,
Yes.
Moon. Lost him. All right, we're count 19, 19-0. Okay. I'm gonna skip over 445 because that might take a second, but who knows what'll happen to 742. 742 is the Delegate Dumais bill. This is the Walter Lomax Act. There is an amendment that brings this and it conforms it to the language in JPR. Is Holly on the line?
Yes, I'm here.
I think it's less than, it maybe has saved a little bit of money, and I think that's why things have gone quiet. Is that right? Or am I
I
wrong?
mean, I can
on that?
walk through the amendments if you
Yeah,
want.
let's do that.
So amendment number one, or Dylan, do you want to put it up?
Yeah, Dylan.
Is Dylan there?
He's having technical difficulties. He's frozen on his end. So
Well, I can run through it if everybody has it. It's pretty simple. Amendment 1 alters the purpose paragraph. Amendment number 2 adds just clarifying language and cleans up that subsection. Amendment number 3 clarifies that the compensation and benefits must come from the state. Amendment number 4 adds requirements for the filing of the order of eligibility. Amendment number 5 is what the chair was talking about. It clarifies when certain individuals can file an order of eligibility and adds certain restrictions for filing. Amendment number 6 adds language to allow an ALJ to modify and recommend a certain payment schedule. And amendment number 7 adds, alters the dates for the retroactive special section.
and Dylan got there at the very last minute, but that's okay. You all should have received these amendments prior to the voting session, so everybody should have them on their computer.
Move favorable on the amendments, Mr. Chair.
There's a motion
Second.
for a favorable and a second on the amendments. Is there discussion on the amendments? Again, they conform to the JPR bill.
I'm sorry, could you briefly walk through them one more time, please?
Holly,
Yeah, sure. So amendment number 1 is just altering the purpose paragraph. Amendment number 2 is adding clarifying language. Specifically, it adds after the erroneous conviction to clarify how much an individual shall be compensated. And number 2, it adds subsequently confined to clarify the findings of the administrative law judge. Amendment number 3 clarifies that any compensation and benefits must come from the state. Amendment number 4 adds requirements for the filing of the order of eligibility. Amendment number 5 clarifies when certain individuals can file an order of eligibility and adds certain restrictions for filing, specifically date restrictions. It has laid that out. And amendment number 6 adds language to allow an administrative law judge to recommend a certain payment schedule and also has a conforming change. Amendment number 7 alters the dates of the special section for the retroactive clause.
Thank you.
You're welcome.
okay,
Question on number 6.
Delegate Conaway.
Yeah, can I get a little clarification on number 6?
Number
Okay.
6 just allows an administrative law judge in certain circumstances to expedite the payment schedule.
Expedite, okay, all
Mhm.
right. Thank you very much.
There's a motion and a second on the amendments. Is there further discussion? Seeing none, all in favor of the amendments, say aye.
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 Is anyone opposed to adopting the conforming amendments? Hearing none. All right, we're on the bill as amended. Is there discussion on the bill as amended?
Move favorable.
Second.
Favorable and a second. Walter Lomax Act. All right, any further discussion?
No.
Seeing none, the vice chair,
Yes.
Anderson,
Yes.
Erican,
Aye.
Bartlett,
Happily, yes.
Hardin,
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanika Fisher,
Yes.
Grammer,
Yes.
Griffith,
Yes.
Lopez,
Yes.
Malone,
Yes.
McComas,
Yes.
Moon,
Yes.
Shetty,
Yes.
Cham,
Yes.
Watson,
Yes.
Williams.
Yes.
And in this case, for the clerk, the chair votes aye, 21-0. Honestly, this has been years in coming, years and years. To do the right thing for Walter Lomax and so many other people. And I am very proud of this committee tonight, very proud of the work that's been done by Delegate Dumais and so many other people. So thank you all very much. All right, let's go to 744, another bill from Delegate Dumais. There is an amendment, and it is a simple one. We'll find out. It changes a word, or it adds "or a respondent," and let's go look up. This is Lauren.
Yes, so this amendment is just expanding the application of the bill to appearance fees for respondents' counsel in addition to petitioners' counsel.
Okay. All right, so it prohibits the clerk of circuit court from collecting fees for docketing the appearance of petitioners or respondents' counsel in certain domestic violence cases.
Move the amendment.
Well, we'll
Second.
move the amendment. There's a second on the amendment. Is there any discussion on the amendment? Seeing none, all in favor, say aye.
Aye. Aye.
Aye.
Anybody opposed? Wait, Delegate Grammer?
No, I'm good. I just have a question on the bill.
Okay, so we'll go to the bill. We'll go to the bill as amended. I hear that the ayes had it on the amendment.
Move the bill as amended.
There's a motion and a second favorable on the bill as amendment. Delegate Grammer.
I support the bill, but as a matter of principle, when do we just strike fees? When do we strike these kind of counsel fees? Can somebody give me why not strike them all the time?
It was intended, Mr. Chair, may I answer?
Yes, please.
It's only intended in domestic violence cases, because those attorney fees, I believe, and maybe the chair can help me with this one. I believe the attorney fees actually go to do something good. I forgot what the purpose of them is, but in domestic violence cases, I think the public policy was that, we wouldn't charge, there wouldn't be a fee.
Okay, thank you.
All right, are there further questions regarding the bill? I see none. Seeing none. All right, we will roll call. The vice chair,
Yes.
Anderson,
Yes.
Erican,
Yes. Yep.
okay, Bartlett,
Yes.
Cardin,
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanika Fisher,
Yes.
Grammer,
Yes.
Griffith,
Yes.
Lopez,
Yes.
Malone,
Yes.
McComas,
Yes.
Moon,
Yes.
Shetty,
Yes.
Cham,
Yes.
Watson,
Yes.
Williams.
Yes.
All right, one more. House Bill 445. We talked about this last week briefly. Delegate Anderson raised a question. We were unclear and people were unclear. And the question was, can you extradite a person if they have committed a misdemeanor? He was under the impression you could only extradite people for felonies. The answer is you can extradite somebody for a misdemeanor. And that's why this amendment was crafted to make it consistent, because in some cases, you might have people crossing boundaries back and forth. They may have committed several, like you could see several shoplifting cases. We heard a bill on retail theft where you could have somebody committing several shopliftings on one side of a border, particularly one side of a state border. Not picking on them, but you could see it in Montgomery or Prince George's County pretty easily. You could see it on I-95 up in Cecil County pretty easily. You could see it anywhere you've got shopping areas close to each other. And so that's why they would need the ability to be able, if necessary, to extradite. She worked with, I think she worked with the advocates on this. I don't believe that anyone is opposed to it. And so the question now is on the amendment. And could I have a motion on the amendment?
Favorable.
Motion for amendment on the second. Is there discussion on the amendment? Delegate Anderson?
No, I was just going to say that I looked it up as well. And to my defense, the word felony comes first, and then they say crime. But, and you knew that, didn't you, Luke? Anyway.
I'm not doing a victory lap. It's late. And
I see the little smug smile on your face, my man.
I don't have a smug smile.
Oh, not now.
I don't.
But
I don't.
If I were okay, go ahead. No, you're right. It's just that in my practice, I had probably represented 10 or 12 people over the years for extradition, and they were all for felonies. And I couldn't imagine that a state's attorney would try to extradite somebody from Texas for a misdemeanor.
No.
The point that you're making with regard to people crossing over from, say, Montgomery to DC, I get that. So
yeah.
Thank you so much for enlightening this young lawyer.
I think it's one of these things there that in my experience, normally you see extradition for felonies. Normally that's what happens, especially if you're going further away. But it's 7:30 and I don't feel like talking a great deal more about it because everybody's ready to stop, right? Or not. We can talk more.
No, I think you're right.
Question. Delegate McComas has a question. Go ahead.
I know everybody's tired. Trust me, I'm a little tired too. I just would like to know, in other words, if I had heroin on me, could I get a citation? Because it's a Schedule 1, right?
No, not right now. No, we had another bill that would allow you to get a citation for possession of heroin, for possession of not marijuana.
Okay, so this would just be if you had marijuana in a certain amount. It would not be for any hard drugs.
Right.
It still authorizes a
It
citation.
authorizes, yes, it authorizes. Oh, I'm sorry. No, that is this bill. God, I'm tired. Okay, let's try that again. That's what this bill does actually, is it does allow for you to write a citation for the possession of heroin, correct? I was focused on amendment, not, yeah, my.
Right, no, I'm sorry. Well, my concern is how much heroin and fentanyl can you have and get a citation?
Fentanyl's a different story.
Fentanyl's a different story, I think is right.
Well, but you can't tell without it going to the lab to be.
All right, but Delegate McComas, let me do this. So the amendment addresses the technical, we're still on the amendment that deals with the technical issue of whether they could extradite a citation.
No, I understand. I jumped ahead. I apologize.
All right,
but-
that's fine. Let me deal with
favorable.
the
No, I'm
amendment.
bad.
You're not bad, but it's fine. Let me deal with the amendment. All right.
Yeah.
All in favor of the amendments, say aye.
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 Anybody opposed?
Aye.
Anybody opposed? Okay, now we're on the bill as amended. Can I have a motion on the bill as amended?
Move favorable.
And is there a second? Fine. Now, Delegate McComas, so your question is, how much? I mean, I believe, and Claire will correct me if I'm wrong, but this has to do with, this simply has to do with the crime of possession of a substance that is not, and that is a controlled dangerous substance, correct? So
Yes.
there are standards by which, yes, that's what it does. So if it were, it would use the same standards by which if it were individually bagged bags of heroin, and there were several of them, then that crime is possession with intent to distribute the heroin. That's not covered in this. This would be heroin for that, a heroin that the officer and that presumably the drug lab would also say, this is not there for distribution. There isn't any indicia that they've bagged it separately, they've vialed it separately, that they have anything else going on. So they're not selling it, it is what that person is using. That's the definition of possession of not marijuana. And I will look to my defense lawyer friends to make sure that I'm doing that exactly right, but there you go.
Mr. Chair, my only concern is okay, let's say I'm a heroin addict and I'm also a hoarder. And so I have a nice big pile of this stuff and it's not in little baggies. It's just, in a nice little jar or something. And it's a fair amount. I guess
then you're probably getting charged with a more serious crime. You're probably getting charged with possession with intent to distribute, or if you're talking about, I'm going to not make light of this, I try not to make light of this, a big pile of heroin, you might be looking at the volume dealer statute. But having said that, if it is just a small amount, the idea behind this bill, as I understand it, and as I've read it, is, and there are cases that come to district court all the time. These are people who get brought in and they get formally arrested for possession of a relatively small amount of heroin. They get brought in for the heroin, they get arrested, they might get released on their own recognizance, and at least during these times, they seem to be getting out a little faster. But in some cases, they get held for possession of a small amount of heroin. And what advocates have said is it makes more sense to give them a citation and get them into drug treatment right away so that then they can begin that incredibly difficult road to recovery. And so that's why the general sense is we don't need to put these people in jail for the possession of a small amount of not marijuana.
I guess what I'm a little concerned about, having dealt with cases where there is that problem and there's children involved, custody situation. I'm not sure a citation they wouldn't just blow off, to be honest with you. And I mean, if you can at least put them in and then recog them to the family and say, and they can get them into a program. I'm just not sure that they're going to do it the first time or the second time or the third time.
I'm sorry to interrupt, but my memory, again, Claire can correct me. I think this is an option for the officer to give a citation. This is not something they must do. So if the officer, if there are other crimes going on, if the officer has had more contacts with this person, then they could go ahead and bring them in. They still could go ahead, bring them in, take them to the commissioner and send them through the process, and they can recog them or they can send them to the detention center. So this just gives the officer the option to write them a citation and then they go from there. And if they don't show up for court, then there's a bench warrant and somebody calls Juanita Fisher or Kurt Anderson or any number of the lawyers on here, and they will try to to get them out of the warrant, but that's a different conversation.
Well, anyway, I'll vote the way I think I should.
Of course, that's fine. Delegate Griffith and Erican.
Thank you, Mr. Chair. So my question for anybody who can answer this question is, so, law enforcement engages an individual, identifies heroin. How does law enforcement then identify if that heroin is laced with fentanyl? Can it be done?
They send it to the drug lab.
So the potential then becomes that they could potentially write a citation to somebody who has fentanyl.
I mean, potentially. I think some are carrying field testing kits, but having said that, the danger in handling fentanyl, they don't like them actually handling and using the substances anymore. So, but even still, they would get the property that effectively the drugs that happen there, and they would be running a drug test on it. That would happen after the person's been released on citation. Well, they can't test the drugs right there. Well, I mean, they could do a field test, but they may not reveal the fentanyl. It may just reveal heroin, and usually officers are going based on their training, knowledge, and experience as to what they see and what they observe and the substance that they find there.
And do we have any sense of, how frequently somebody who has possession of heroin has possession of fentanyl? Is it? I know it's in Harford County is becoming increasingly common, and Harford County is a county specifically that's been hit very hard by the opioid crisis.
Look, I mean, honestly, I don't know that there's a part of the state that hasn't been hit hard by the heroin crisis. I think the reason that we're talking about this now is we want to get them into treatment. We don't need them to be. We don't need them locked up in local detention centers for relatively small amounts. And quite honestly, if they're writing a citation and they find out that it's heroin and fentanyl, we might have actually saved the person's life. We might have actually, I mean, the scenario here is they write a citation, they take them to, like, for example, one of the places here in Anne Arundel County, they take them to a place where they can get on-demand treatment. They get sent to that treatment. You know what? That is probably the better result. And
does the person?
That's the better result.
And this mean legitimately not I'm sorry, I'm tired. Legitimately not understand the process. Can that person then is that person compelled to stay at that treatment facility, or can that person leave at any time?
Well, I mean, so that's a different question. So what we're dealing with here is the question here is this bill would give the officer the ability to give somebody a citation. The next steps are, to be honest, are going to be up to them, but you could see how local health department saying, okay, well, the officer says, here's more information about treatment. Here's more information about, I mean, the challenge with treatment, especially for heroin, they also have to engage in that treatment. But we through justice reinvestment and other ways have certainly expanded the range of different kinds of drug treatment that's out there. Whether they stay, I mean, look, in my life, yeah, you get to see a lot of people who don't stick with the treatment, but it doesn't mean you don't keep trying. Especially with heroin, sometimes it's 2 steps forward, 1 step back, 2 steps forward, 4 steps back. So you just have to.
And I don't disagree with you, Mr. Chair. I'm just very, very worried about, even more than the heroin issue, the fentanyl problem.
Yeah, I agree. No, I don't take anything away from that at all. But
thank you.
Let me go to Delegate Erican, then Bartlett, and then I think we're going to move to a conclusion here. Delegate Erican.
Thanks, Mr. Chair. I did ask my my local and sheriffs about how much fentanyl is in heroin, and I think they said 98% of heroin has fentanyl in it now, at least in our county. So it's almost all of it. My question is actually for Claire. One of my questions is for Claire. Can you tell us the list of things that are on the 90 days, what are those things, those misdemeanors that carry up to 90 days that's listed in the bill? It references it, but I don't have the actual code here that tells me what those things are.
Where are you seeing this?
This is on page 2.
Oh, okay.
Yeah, line 25.
The maximum penalty is 90 days or less.
Yeah. What kind of things are those?
Trespass. The Jean Valjean of theft under $100. Claire, if you've got other ones.
Several driving offenses.
Many driving without a license, driving suspended. But that wouldn't necessarily, I mean, you'd be getting citations for those probably anyway.
Except for the C.
Except for the C. Except for the driving suspended C.
What's that? Oh, a class C.
Yeah. So what is under one of the more common under 90-day offenses that's actually cut out of the shall issue citations is failure to comply with a peace order. So that's another one that is 60-day.
So that would fall under here?
So no, they would not be able to write a citation for the failure to comply with let me restate that. In the law and in the current law, and even if the bill were to pass, you would not be able to get a citation for the failure to comply with a peace order. You would be able to get a citation for the failure to comply with a protective order. So yes, those are
the main
non-citable. You're not able to get citations for those.
Okay, so trespassing, theft under 100, and
things like that. There's if you want me to go through all of the crimes, then we could talk to David Moon, and he probably could start rattling off more of them. And I'm not making light of David again.
It's not because he has experience. It's just because he knows the law very well.
No, it's just because this is one of the issues that we do deal with on the committee is the crimes that carry less than 90 days. By the way, for the committee, before we all lose it, just so you're aware, you can go to the Maryland Sentencing Guidelines website, and if you want a list of all the crimes ever, you can go on their site and look at Appendix A, and you can see all the different crimes that we have and their maximum penalties.
Okay.
Something you can read.
Yay! More fun reading. I have one last comment on it because there's discretion, which normally I know we like to give people discretion, except for lately with the racial disparity issues. My only comment would be in certain areas where, I don't know, we may be under consent decree or something like that, where there's been traditional issues. Could this open up the people who are just more likely to have interactions with police officers? Like you had mentioned, if somebody recognizes somebody as somebody they've seen a lot, they don't have to issue a citation to that person, but is that going to speak to issues with disparity where you see somebody you just don't really like?
Well, I think what the bill is doing is it's expanding the ability of people to write a citation. So if anything, if it were in this case, I would argue that if you believe, and I think you believe that the people who are being arrested more for these crimes were people of color, then this gives officers the ability to write them a citation as opposed to taking them to the detention center.
Yeah, I definitely authorize it.
Whether they do that
outcome is
a separate issue, and another issue that I feel like we probably will be taking on in years to come. And I'm watching Delegate Davis nod her head up and down.
All right, thank you. I share the same concerns as Delegate Griffith about the fentanyl, though, but I thank you.
Delegate Grammer.
Thank you, Mr. Chair. Question about how this works. So this specifies that as drafted, any other misdemeanor or local ordinance violation not involving serious injury, et cetera, shall charge by citation. So we had a situation in Essex along the commercial space. Young boy, his parents couldn't handle him, went to his grandparents. Grandparents couldn't handle him. They kicked him out of the house. He's got a mental health issue. He's sleeping on a mattress in the rain. He's got a drug addiction issue and an alcohol addiction issue. The cops know who he is. We're just looking to get him some kind of resolution. The cops are not arresting him. He's clearly guilty of multiple crimes, which would fit this 90-day, 90 days under this bill. And the cops aren't arresting him. They actually took him to a addiction diversion program.
How old is he?
He's like 23.
Oh, you said young boy. Okay.
So they take him to diversion program. He ends up right back in the same mattress in the same area. They didn't want to, but they had to arrest him because this chain has to break. And that's how he started to get treatment. Like, we knew his name, we knew the house he came from. But as you look at these situations, how they play out, maybe there's just something I'm missing, but the police eventually were like, look, we just have to get this guy services. We're going to press charges. We're not looking to put him away forever, but this is the only way we know to get him. We can't just commit people in Maryland. And this is how they got him services. And I haven't heard recently an update on him, but what's the alternative in a situation like that? Because this is not a bill that says may, this is a shall.
It's a shall in certain cases. If it's the possession of not marijuana, if that person had a small amount of heroin with them, they could, and what it sounds like they have, or maybe it's not heroin, maybe it's some other controlled dangerous substance, they would be able to still, because that part is a may, they would still be able to arrest them, take them in, and get them, if that is the faster way to get them inpatient treatment. How all the way across the state, there are varying levels of different treatment programs that police officers are also taking them to. And in fact, in Baltimore City, there's a program that is diverting people altogether from the criminal justice system right out of the gate. That's been working with people and taking them to treatment programs.
But
again, the point behind this bill is for people who in possession of that amount of not marijuana, getting them closer to treatment and getting them closer to treatment sooner is better for them. It's better for our local detention centers. It's better for pretty much everybody. And if we can do that by citing them and giving them a citation as opposed to locking them up and putting them in the detention center, then that's the may there. And then on the shall side of it, it's a relatively, the change on the shall side basically limits it to a very limited number of cases where they can cite, where they shall cite. And I would think that would be low level, a super low level theft or a trespass or something along.
But that comes, those are the crimes that come right along with the addiction issue, because where do you find these guys? You find them in a shed. They're hawking people's weed whackers. And you can't.
Well, that's second degree burglary.
No,
then they can charge them with second degree burglary. If they're breaking into somebody's shed and stealing weed whackers and taking them down to the pawn shop, it's a second degree burglary.
And if I may add, even the where a police officer shall charge by citation is subject to paragraph 2, which is at the bottom of page 3, which says that a police officer may charge a defendant by citation only if these 5 conditions are satisfied. So in that situation with the young man who was sleeping on a mattress, if this, the police knew who he was doing this all the time, if the officer reasonably believes that the defendant would not comply with the citation, then they could charge him.
I'm looking at the bottom of page 3. I don't see that.
It's right there.
Current law. In the current law line.
Current law.
Line 26.
Line 26.
Mr. Chair, is there a question?
Oh, Lord.
I will yield. Thank you, Mr.
All right. The vice chair, I think, is going to say something people want to hear.
Yeah, let's
The
move the
previous
previous
questions.
question, please.
All right.
Second.
The motion, there's a motion for the previous question, moved and seconded. We're gonna, all in favor, say aye.
Aye.
All right. We're on the bill as amended.
Move favorable on the bill.
We
as
already
amended.
did that. We've got a motion for a favorable and a second. We're ready for the roll call. The chair.
Yes. Did you say the vice?
Anderson. Sorry?
You said me, the vice chair?
Yes, yes.
Oh,
you.
yeah, yes.
Yes. Anderson.
Aye.
Erican.
No.
Bartlett.
Yes.
Hardin.
Yes.
Conaway.
Yes.
Cox.
No.
Crutchfield.
Yes.
Deborah Davis.
Yes.
Juanita Fisher.
Yes.
Grammer.
No.
Griffith.
No.
Lopez.
Yes.
Malone.
No.
McComas.
No.
Moon.
Yes.
Shetty. Shetty.
Sorry, I froze. Yes.
Cham.
No.
Watson.
Yes.
Williams.
Yes.
I think that is 13-7. All right, we're almost done. Seriously. Adding more bills to subcommittee lists, including House Bill 270 from Karen Young, Delegate Karen Lewis Young, to criminal law. Adding several bills to civil law, including the SLAP bill from Delegate Rosenberg, House Bill 308, and several estates and trusts bills, including House Bill 766 from Delegate Terrassa. Well, this isn't really an estate bill, but it's a judgment bill. House Bill 772 from Delegate Queen on exemptions from execution. House Bill 848, which came from the Attorney General on body attachments and small claim civil cases. House Bill 870 is a estates and trusts case. I'm sorry, it's all I have to do not to say stiffs and gifts. And then House Bill 1250 from Delegate Malone on the task force on intestacy. And House Bill 1261, 1264, and 1266, all three estates and trust bills from Delegate Fisher, giving civil law a little bit more to do and criminal law. We have the Public Safety Subcommittee meeting from 9 to 11 a.m. on Monday, the 1st of March. 11 to 1 is the Criminal Law Subcommittee. We are having hearings with 125 witnesses on Monday at 1:30. On Tuesday, the 2nd of March, we have a 10 a.m. floor session. 12:15 to 1:30 is the Family and Juvenile Law Subcommittee, or the Juvenile and Family Law Subcommittee. It's very confusing. And then at 1:30, we have hearings and only 21 witnesses. There you go. It's been a pleasure this week. It's 8 o'clock. Good night. Thank you all very much.
Bye.
Good night.